right. Welcome to the Robert H. Jackson Center. My name is Kristen McMahon, and I have the privilege of serving as the president here. Thank you very much for joining us for the third program in our 2026 series, 25 Years of Asking Questions. Our thanks to Southern Chautauqua Federal Credit Union for sponsoring this series this year. A few housekeeping notes before we start. Please make sure your mobile phones are silenced or turned off. Inevitably, one of them will ring. Last time it was mine. It was very embarrassing. And if you need a restroom, they are right outside the doors to the left. There will be some time for Q&A after Professor White is done with his talk. And finally, this program is being recorded and will be posted on our YouTube channel. Good chime. The Robert H. Jackson Center is a nonpartisan nonprofit and a registered 501c3. Because education is such a critical part of Robert Jackson's success, we do not charge for any of our programs, events, or tours of our space. Our success and sustainability is 100% reliant on philanthropy. So, if you would like to support any of our programs, our mission, our work, please consider making a donation today. And David and I, of course, would be happy to chat with you about that. We have a myriad of anniversaries to celebrate this year. First, we are celebrating the 250th anniversary of our country. And the center has a very long history of civics-related programming, and that is certainly continuing this year. We kicked it off in January with our 1A Day. We are continuing through a series of programs geared towards students this spring, and of course, as always, we will do Constitution Day in the fall. Second, we are about halfway through the commemoration of the 80th anniversary of the International Military Tribunal at Nuremberg. We kicked off a worldwide symposium on November 21st, the actual 80th anniversary of Jackson's opening statement at the tribunal. And this international series, with more than a dozen partners around the world, is designed to run the entire length of the trial. And so there will be one program a month through October of this year. These programs are all held virtually, and the next one actually is the center's own program on April 10th at noon. This program is called The Ethics and Philosophy of Prosecution, Justice versus Revenge. And our guest speakers will be Professor John Q. Barrett, our Elizabeth S. Linné Fellow, and he'll be providing the Jackson perspective, of course. And then David Crane, the former chief prosecutor for the Special Court for Sierra Leone, providing the modern perspective. This summer, third, we will be celebrating the 85th anniversary of Jackson's appointment to the Supreme Court of the United States. Stay tuned for what programming is coming with that. And finally, I told you there were a lot. Finally, the center kicked off its 25th anniversary starting in December of 2025. For 25 years, we have brought historic figures, renowned authors, passionate practitioners, legal luminaries, you know how I like my alliteration, and teachers of all kinds to Jamestown, to Chautauqua County, to Washington, D.C., to Nuremberg, and to your computer screens. We have hosted conversations on challenging topics, created informative exhibits on Jackson's life and cases. We have augmented student learning on the Holocaust, civil rights, the legal system, and history in general. We have inspired interns and fellows, some of whom are with us this evening, to pursue their dreams, and frankly, educated anyone who would stand still long enough to listen. We have enjoyed learning with you, and we look forward to continuing to do that. So as I said at the outset, our program theme for our 25th anniversary is 25 years of asking questions. One of the fundamental concepts of the center is that we do not tell you what to think. We give you access to experts and information, and then the tools to help you determine how you want to think about things. Analyze those thoughts, and then take them out into the world to hopefully do something good with them. All of our 2026 programs lean into this deeply. We started in January with Do We Still Believe in Free Speech? Followed by February, Who Gets to Go to School? And in March, our theme is What Makes a Life Matter? Robert H. Jackson ends his eulogy to Mary Willard, his English teacher at Jamestown High School, with the beginning of a George Eliot poem. And let me share that with you. Oh, may I join the choir invisible of those immortal dead who live again, in minds made better by their presence, in pulses stirred to generosity, in deeds of daring rectitude, in scorn for miserable aims that end with self, in thoughts sublime that pierce the night like stars, and with their mild persistent urge man's search to vaster issues. So to live is heaven. Earlier in that eulogy, Jackson writes, a correct and full understanding of the written word is the threshold of knowledge, and ability to write simple, direct English is the beginning of power. A noble thought, worthily expressed, a dramatic event graphically described, a knotty problem lucidly stated, were marks of the craftsman, and in a student, foretellers of a career. This seemed a very fitting way to start the introduction of Professor G. Edward White this evening. Last fall, Professor White's book, Robert H. Jackson, A Life in Judgment, was published, and it has been nearly 70 years since the last be the center's very first program participant. Professor G. Edward White joined the Virginia Law Faculty in 1972 after a clerkship with Chief Justice Earl Warren of the Supreme Court of the United States and a year as visiting scholar at the American Bar Foundation. He was appointed the John B. Minor Professor of Law and History in 1987 and held that chair until 2003, when he became David and Mary Harrison Distinguished Professor of Law. In 1992, he was appointed to a university professorship, which he held until 2003. And from 1990 until 92, and again from 2001 to 2003, he was the Sullivan and Cromwell Research Professor. From 1994 to 1997, the E. James Kelly Research Professor, and from 1999 to 2001, the class of 1963 Research Professor. He has held visiting appointments at New York Law School, William and Mary School of Law, Brooklyn Law School, Arizona College of Law, the London School of Economics and Political Science, and the University of Auckland Law School, as well as a little school in the Northeast called Harvard. He has been a Guggenheim Fellow, twice a Senior Fellow of the National Endowment for the Humanities, and he is a Fellow of the American Academy of Arts and Sciences, a Fellow of the Society of American Historians, and a member of the American Law Institute. Professor White's 20 published books have won numerous honors and awards. These include final listing for the Pulitzer Prize in History, the Silver Gavel Award from the American Bar Association, the James Willard Hurst Prize from the Law and Society Association, the Littleton Griswold Prize from the American Historical Association, the Scribes Award, and the Association of American Law Schools Triennial Coif Award. We are so delighted to have Professor White here this evening for what I have been referring to internally as our first TED Talk. I'm sure you get that often. And Professor White, we are very pleased to welcome you.
Thank you, Kirsten. I'm paying a special thanks to two people in connection with this visit. One is Greg Peterson, who invited me, first came down to Charlottesville to interview me for the center, and then turned around and asked me to come back. I said I'd never been to Jamestown, and he said, well, I'll work that out, and he did. And Greg has been a enthusiastic companion and intellectual compatriot, so I appreciate his help. The other person is Scott Sawyer, who is not only providing my transportation to and from the Buffalo airport, but loaned me his coat when he realized that I was ill-prepared for Jamestown weather, and I made very good use of that this morning. So, Scott, I'll give it back to you. The defendants does some estate work. It's just a diverse practice and quite a thriving practice. So by 1934, when he's recruited by the Roosevelt administration, he's making over $30,000 a year. Now, that's about $400,000 a year in today's dollars. So that's for an area like Jamestown, that's making him a comparatively wealthy person. He's gotten married. He has 2 children. He's bought a house outside of Jamestown with land and racing and horse stables. He's a great rider all his life, and so is his daughter Mary. And he's quite content. Indeed, at one point in the 1920s, after Franklin Roosevelt becomes governor of New York, Roosevelt and Jackson go back to 1912, initially when Roosevelt was Assistant Secretary of the Navy, and Jackson was a member of the Democratic Committee for this region. And for some reason that escapes me, Roosevelt, as Assistant Secretary of the Navy, had patronage control over postmasterships in Western New York. And so Jackson would go down to Washington to lobby Roosevelt for, on behalf of particular candidates for postmasterships. So he got to know Roosevelt, but they don't have a particularly close relationship. And Jackson leaves the Democratic Committee fairly early on to concentrate on law practice. And when Roosevelt offers him an appointment to the Public Service Commission after he's become governor, Jackson turns him down. Says he prefers it would be a kind of one-sided job, and he prefers the diversity of law practice. So when the Roosevelt administration comes calling after Roosevelt is elected in 1932 and seeks to staff Washington offices and agencies with new personnel, wants to expand the size and activity of the federal government, 2 of Roosevelt's associates come down to Jamestown and seek to persuade Jackson to join the Bureau of Internal Revenue. Jackson has had a lot of different kinds of experiences in practice, but tax law is not one of them. So he tells the recruiters that he has no experience with tax law. And they say, don't worry about it. So he says, well, I'm a little tempted to come, but I can only come part-time. I don't want to leave my practice. So, well, yeah, let's try it that way. Well, that works about for 6 months. It's just too burdensome to commute back and forth. And eventually, Jackson disbands his practice, just retaining some contacts with clients, mainly in trusts and estates. You could do that in those days. It wasn't perceived as a conflict of interest for somebody who worked for the government and had private practice. Sorry, that's no longer the case, but so he retained those connections for a while. But in any event, he joins the Bureau of Internal Revenue. Now, this is at a quite substantial cut in salary. It may be that moving to Washington was influenced in part by his children's education. Mary and Bill, his 2 children, were students at Jamestown High School at a time when Jamestown High School was being renovated, and the renovations were extensive, and the school decided to close for part of the day. Jackson felt, based on sort of a extrapolation from his own childhood, that going to school half a day was not going to be conducive to a good way to spend a teenager's time. That teenagers would not having to face responsibilities in school might be at loose ends and might get into difficulties. So he wanted to get his son and daughter out of the Jamestown schools, and he looked into various schools, and he was interested in what he called church schools. These were really Episcopal schools, and Jackson was interested in them for a couple of reasons. He first of all thought that at least the Episcopal schools were not overly proselytizing. They didn't include a lot of religion in their curriculum, but also they were not so inclined as some other boarding schools to encourage their students to spend money, live the high life, and think of themselves as wealthy elites. Jackson didn't want his children having that consciousness. So he goes to Washington and he moves into the Wardman Park Hotel. And the Jacksons stay in the Wardman Park Hotel for the next 7 years. Now you may say, why? Why didn't he buy a house or even just rent a house? I think the answer was that Jackson was always thinking about going back to Jamestown. If a particular job in the Roosevelt administration wasn't to his satisfaction, he just thought he'd resign and go back and resume his law practice. So he didn't really put down substantial roots in the District of Columbia. But then when he gets nominated to the Supreme Court in 1941, he buys the house called Hickory Hill, a house that subsequently was lived in by Robert Kennedy in McLean, Virginia. They bought the house, the Jacksons bought that house in part because it had land and riding stables. But they don't do that until 1941, and the contract for the house, sale of the house, provides that the sale is contingent on Jackson successfully being appointed to the Supreme Court. So he's not going to buy a house until he recognizes that he's probably going to be a long-term resident of Washington. So why did Jackson do this? I mean, why take on a job as a tax lawyer with no tax experience at a substantial cut in salary, moving away from Jamestown, which he said in his memoirs was a great tug? I mean, this was after all where he'd grown up, where he'd prospered, where he'd established himself in not only in his law practice, but as a substantial member of the community. Why and where his home life was fulfilled and happy, why leave? Well, I think one major reason was his attraction to Franklin Roosevelt. Once Jackson came to know Roosevelt and work with Roosevelt, they had a very pleasant mutual relationship. They liked one another. They got along with each other informally. Roosevelt was very inclined to have informal, humorous relationships. Roosevelt did a lot of his internal politicking and policy work informally. He would have cabinet meetings. Jackson talks about this when he was Attorney General and went to the cabinet meetings. Roosevelt would have cabinet meetings, and the various members of the cabinet in sequence would detail what they'd been doing and what they proposed. And Roosevelt was frankly bored. And sometimes he would try to stir things up, ask provocative questions or try to pit members of the cabinet against one another just for fun. But when there was serious work to be done, he'd invite somebody over for lunch or breakfast or an informal chat. And Jackson liked that. That was very much Jackson's style. And so over the years, he increasingly came to admire Roosevelt. And Roosevelt was responsible, either directly or indirectly, for every job in Washington that Jackson had, including eventually the Supreme Court. And so I think one reason Jackson stayed was Roosevelt. I think the other reason was that in Jackson's 7 years in the federal government before he was named to the court, he had a variety of different positions.
He was with the Bureau of Internal Revenue. He was with the Antitrust Division. He was with the Solicitor General's office. He was Attorney General. And Jackson really liked learning new areas of law, as I put it, from the ground up. He liked just going into an area where he knew comparatively little, mastering the details, and subsequently feeling confident about his performance. Jackson was gifted in numerous ways. He was a very gifted appellate advocate. Even though he had not done appellate litigation in Jamestown, he quickly learned how to do that. And I was talking at lunch today about a portion of a chapter he wrote in his memoirs on the Solicitor General's office. Jackson was Solicitor General from 1938 to 1940, and it's a primer for how to give appellate arguments. And the two propositions that Jackson endorses is, one, be thoroughly prepared. Be so prepared about every dimension of your case that no matter what the judges ask you, you have thought about that. And the other is, go into your oral argument presentation without, you may have an agenda, you may have an outline of the argument you're going to make, but be prepared to get off that argument as the justices and judges ask questions. Be flexible. Sometimes you may decide, given the way the justices are asking questions, that you're going to not make arguments that you were planning to make. But those, as anybody who has done appellate advocacy knows, those are cardinal rules for effectiveness. And Jackson was an extraordinarily successful Solicitor General, winning 38 out of 43 cases he argued before the Supreme Court. Justice Brandeis was perhaps apocryphally remarked to say that Jackson should have been made a Solicitor General for life. That is the first professional displacement. From Jamestown to a prosecution against former Secretary of the Treasury Andrew Mellon, working for the Bureau of Internal Revenue, and then on to the Justice Department, and then eventually Solicitor General and Attorney General. The third transition is to Nuremberg in 1945 as Chief Allied Prosecutor. But to understand that displacement, one has to understand the second one. And that's the displacement that Jackson engaged in, encountered, let's say, when he was named to the Supreme Court. Now you may think that calling that displacement is an odd term. I mean, after all, he's been an advocate in federal cases, including the Supreme Court, for much of his time in Washington. He's just going to be basically on the other side of those cases instead of arguing them, deciding them. But it's very comparable subject matter. And moreover, he possesses skills that are completely consistent with being an effective Supreme Court justice. He's a very quick legal analyst, a very quick and acute legal analyst. He sees to the heart of legal issues quickly. He's a very gifted writer. He's a quick study and can learn the details of cases promptly. He's got all the tools that one would associate with making the transition to a Supreme Court justice easy. So why am I calling it a displacement? Well, because of the atmosphere that Jackson encountered on the court, and the change that was required for him to move from someone who is essentially an advocate, arguing for cases that he is doing representing his clients, not necessarily representing his own views, to one where his role is that of an impartial arbiter, not an advocate, not engaged in the same fashion. And there's a passage in Jackson's memoirs where he says, the job requires a significant psychological change in moving from the role of an advocate to that of a judge. Some do this better than others. I'm not sure I've been very successful at it. And I think he was candid in that. I think Jackson had trouble not rushing to judgment as a justice, that he's quickly figuring out what the way he wanted to come out on a case and advancing the reasons for why. But in addition, the Supreme Court of the United States is a collegial body. It makes decisions collectively. You need at least 5 judges for a majority. Sometimes you'll have 9 judges participating, but you have, in every case, you have regular exchange among the judges while they collectively work out their positions. And that often involves compromise, trimming back one's views, deciding grudgingly to go along with a position that one doesn't really feel strongly about, trading off votes sometimes. There's an atmosphere of collegial politics that's a regular feature of the court's business. And Jackson didn't like that and wasn't particularly good at it. He didn't like it because he valued his independence. Independence was a cardinal principle of Jackson as a judge. He wanted to work out his views on cases by himself. He didn't rely on his law clerks. He didn't rely on conversations with other justices. And he was loath to be persuaded by other justices who sought to lobby in order to get him to join their side. He resented that. There was another feature that contributed to the somewhat awkward transition that Jackson made from the government to the court. When Jackson was nominated, it was because Chief Justice Hughes had retired. So the Chief Justiceship was vacant. Jackson was widely regarded to be a leading candidate for that position. He didn't have any previous service as a judge, but he was a very well-known figure in Washington legal circles. He was extremely well qualified for the job, and he was a strong supporter of Roosevelt's. Roosevelt initially wanted to name him Chief Justice, but in the process of considering that, Roosevelt, consulted Charles Evans Hughes, the retiring chief, and Hughes said, well, I think Jackson is extremely well qualified for the job and would be a very good Chief Justice, but I don't think that a person who has had no experience with the court ought to come on and be Chief Justice right away, because there's some features of court life and work that it would be helpful to be accustomed to before you became chief. And so perhaps promoting one of the associate justices to chief would be better, and then Jackson could fill that justice's position. And Hughes suggested Harlan Fiske Stone, because by July 1941, when Jackson's nominated, the U.S. is on the brink of entering World War II. Stone had been a Republican appointee, appointed by Coolidge, and Hughes thought it was a good idea for Roosevelt to consider Stone as a bipartisan appointment. So finally, Stone is 69 years old at the time, and there is a statute that provides that justices who retire at the age of 70 can do so with full pay. And Stone had signaled that he might be interested in retiring. Stone and Jackson discussed the matter, and Stone says, I'm not planning to stay on very long, and you'd be a worthy successor. And so the plan goes forward, and Stone is named chief, and Jackson is promoted to associate justice in his stead. Stone does not retire, and in fact stays on the job until he dies. But in any event, other New Deal appointees and other Roosevelt appointees, particularly Justices Black and Douglas, resent the fact that Jackson, junior to them and somewhat not on the court, might be considered to have been elevated over them for the Chief Justiceship. So they're a little bit apprehensive about Jackson's coming and not particularly welcoming. And very early in Jackson's career, he encounters the phenomenon of intra-court politics, personified by Justice Black. Black at this point in his career is not the sort of First Amendment absolutist. He is coming out of the Senate, and he is quite a partisan ideologue who is still learning, really, how to be a judge. And he initially believes that he can identify the outcomes in cases that he supports and then spend most of his time trying to round up support for his positions. And he approaches Jackson in that way, thinking Jackson, after all, is a Roosevelt appointee, a New Deal supporter. Why wouldn't he want to go along with a lot of Black's agenda? And instead of welcoming that, Jackson resents it. So Jackson and Black don't get off the ground very well. And their relationship sours even further in 1945 when, in two successive cases, Black's former law partner, Crampton Harris from Birmingham, Alabama. Harris and Black practiced together for many years in Birmingham before Black became a senator. Harris is representing mine workers in two cases involving whether mine workers should be paid for transit to and from the mines, not just the time spent in the mines, under the Federal Employees Labor Act. Black feels strongly that they should. Harris is representing the miners in the cases. The losing company, Jewel Ridge, owner of a mine company in Virginia, asks for a rehearing after losing the case on the ground that Black should have recused himself because of his relationship with Harris. Judicial recusal is an individual matter. Whether a justice decides that he should disqualify herself or himself in a case is up to the individual judge. When the company files a petition for rehearing, Jackson takes the position that the court should signal that they're denying the rehearing because Justice Black has declined to recuse himself. Black is annoyed at that. Black wants what he calls a mere denial. That is simply a summary denial of the petition without giving any reasons. Jackson says, I'm not going along with that. The motion was not directed at me or any of the rest of us. Indeed, Jackson dissented in the case. It was directed at you. The basis of the rehearing was your relationship with Harris. So if you're not prepared to signal that, I'm going to write a concurring opinion in which I say that. And Black says, if you do that, that's going to amount to a declaration of war. So it's a tense conference, and eventually Jackson does write a concurrence. But in the meantime, Stone has died and Roosevelt has died, and so there's a new vacancy for the Chief Justiceship, and there's a new president to nominate President Truman, and once again Jackson is identified as a prominent choice. In the meantime, Jackson has been approached by a man named Sam Rosenman, representing members of the cabinet that have contrived a plan to, by now World War II is winding down. We're close to VE Day. And there's been planning going forth to try the leading Nazis as war criminals. And the plan put forth and proposed by Rosamond to Jackson would have a relatively straightforward Anglo-American due process criminal trial where the Nazis would be indicted for war crimes and their guilt would be determined in the ordinary legal process. And Rosamond says to Jackson, how do you feel about being the chief prosecutor in this tribunal? And Jackson is sorely tempted to take the job partly because of his poor relations with the court, and partly because he believes very strongly in the rule of law and due process and wants to try to see if he can vindicate that in Nuremberg. So he takes the job and leaves the court. And Stone, he's talked to Stone about this before Stone's death, and Stone says, I don't think you should go. Your absence is going to be a complication for the court. That will leave 8 of us. We may be equally divided in some cases. With your not being present, we can't resolve them. I think any trial of the Nazi criminals will be a show trial. I don't see how you can encourage anybody that this is a fair, ordinary U.S.-type criminal trial. So I don't think you should go. And Jackson says, thanks, I'm going. And then begins what he doesn't anticipate, an extended series of negotiations with the other allies about the format of the trial. All the other allies begin with the idea that they should just summarily execute the Nazis. There's no need to have a elaborate trial. The Nazis are clearly guilty of war crimes, and so let's just demonstrate that and put them to death. Even the British are initially of that position. Jackson then has got to persuade all the other Allied nations that the format he wants is preferable, and he eventually does. But it takes him until November of 1945 to do that. So the Nuremberg trials do not begin until a very extended period. And Jackson is largely responsible for the format, with one exception. There are judges from the individual nations at the tribunals. Each nation has a primary judge and an alternate judge. So 4 judges composing the tribunal. And the tribunal decides that they're going to give the Nazi defendants greater latitude than they would ordinarily have at Anglo-American criminal trials. That is, they don't have to necessarily be responsive to prosecutorial lines of questioning. They can deviate from them, they can digress, and that practice will be upheld by the tribunal. And in Jackson's cross-examination of Hermann Göring, on the first day of that cross-examination, Göring tells stories, makes patriotic comments about the Nazis, doesn't respond to Jackson's questions. Jackson encourages the judges to require Göring to be responsive and is told, no, the defendants have greater latitude. After the first day of questioning, Jackson is furious, comes up to the judges and says, you're killing me. How can I engage in a prosecution if the defendant can just go off on the tangent and not even respond to my lines of questioning? And they try to, and he said, I might as well quit and go home, if that's the way this is going to proceed. And they try to placate him, and eventually comes back the second and third day, where his examination of Göring is more effective, in part because given greater latitude, Goering just starts telling prideful stories about what the Nazis did and all their policies and contributes to his own incrimination. But Jackson receives a certain degree of criticism. The press picks up on the first day, and there's a lot of talk about how Jackson failed in the movie Nuremberg, which I see you're going to be shown here. Some of you have already seen it. Makes much of this and suggests that Jackson flopped in the prosecution of Goering and was rescued by the British judge Maxwell Fyfe, the British prosecutor Maxwell Fyfe. That's not really accurate, as much of the movie is not really accurate. In any event, Jackson comes back to the court, but there's one other episode involving Black before he does. While he's over in Nuremberg in the spring of 1946, an article appears in the Washington Star by Doris Fleeson, in which she tells the story of Black and Jackson's confrontation in the Jewel Ridge hearing case. And she tells it in some detail. Obviously, there's been a source on the court that's leaked information to her. Jackson sees the account, and he realizes that it's only partially correct, so he decides that he's going to issue his own version. And he does in the form of a cable to the House and Senate Judiciary Committees, in which he goes through and says, among other things, I told Justice Black, in words which I would use again today, that I would not stand for any more of his bullying, and that if he persisted in this practice, repeated this practice, I would make my concurrence look like a letter of recommendation. So all of this gets in the press, and some papers call for Jackson to resign, and some papers call for Black to resign. But Jackson says in his memoirs, my relationships with Black were cordial ever since then. We treated each other as gentlemen. And he said, I wonder how that would have been without my cable. But when he goes back to the court, he's chastened to some extent by his experience at Nuremberg. He's seen the evil with which totalitarian states can infect their entire populations. He's been, of course, a libertarian on free speech prior to going over there. He's written the opinion in Barnette. He's dissented in the Korematsu case. His reputation in domestic issues is that of a civil libertarian. But after Nuremberg, he comes back and he's something of a cold warrior, much more inclined to worry about the capacity of unregulated speech to do violence. And so he writes a couple of decisions in communist cases where he basically takes the position, the communists are not going to, they're seeking to overthrow a government. Should we wait until that happens before we repress their speech? So in the latter stages of his career, he is much more of what you might call a unpredictable, moderate jurisprudence jurist, supporting civil liberties in some cases and not in others, favoring federalism in some cases and not in others. Had he lived and remained on the Warren Court, I think he would have been in dissent, along with Frankfurter, in a number of areas where the Warren Court attempted to engage in constitutional reform. Don't know about reapportionment, but certainly in criminal procedure. Jackson was inclined to allow the states more latitude for their own procedures. Jackson participates in Brown versus Board of Education. And I found the materials in the Jackson papers very instructive in that respect. Jackson was troubled. Jackson was on the court in two terms when they contemplated Brown. And in the first term, the 1952 term, the court is quite split. Vinson is dead against overruling Plessy. Frankfurter is uncertain. Reed seems to be against. And Jackson is having real problems because he can't really find a principled legal way to overrule a precedent, which after all, if the 14th Amendment prohibits racial discrimination, then why after its passage in the public schools, why after its passage were there segregated schools? Not just in the South, but in the North. So Jackson is really struggling with a principled basis for overruling Plessy. And so he does what's very characteristic. He writes memoranda to himself. And as the court begins to work out, as more and more justices go on board with overruling Plessy, Jackson writes successive memos in which he tries more and more to convince himself to go along with that. And eventually produces a late memo in which he concludes that he does support it, but it's unclear whether he's going to write separately or join the court's opinion. And then he has a massive heart attack. This is in March 1954, and he's in the hospital for 2 months. He returns to the court to sit while Warren delivers the opinion in Brown. By then, Jackson has joined the opinion. But then he goes back into the hospital and he recuperates over the summer at a resort in California called Bohemian Grove and prepares to join the court in its October term. And the first week of that term has a heart attack and dies. It's a life cut too short. And it's a life where we can only really speculate what he would have done had he remained on the court, what kind of justice he would have been. But if you think about it, it's a remarkable life, going from the child of dairy farmers in Spring Creek and Frewsburg to law practice in Jamestown, to a series of important positions in the federal government, to a membership on the Supreme Court, to the chief prosecutor at Nuremberg, back. These professional displacements, I think, although they took their toll on Jackson, are ways that we can imagine a life worth remembering. Thanks. I haven't seen any evidence of that. But the Jackson papers are filled with Jackson's own recollections of events. Not just his case files, but he wrote an autobiography in 1944 that covers his early life, doesn't talk about the court in considerable detail. He gave an oral history memoir to Columbia University in 1952 and 53 that does have a section on the court. He was constantly writing down things that happened to him. And I think that was just his style. When he wanted to think about something, he resorted to writing. And at one point I was talking about this, and I think there are 4 really gifted justices that have been writers, really gifted writers as justices. Chief Justice Marshall, Holmes, Cardozo, and Jackson. Marshall, Holmes, and Cardozo had the capacity to dash out first drafts that were so eloquent that they didn't really need much revision. That wasn't Jackson's style at all. He would write and rewrite and polish and polish. And why did he do that? I mean, he was good in the first place. He just liked it. He just liked writing. That was his métier. Yes, ma'am.
So when Jackson's on the court, we can see that he's a very restrained justice. He tends to defer to government, to Congress and the president. There are some authors that make the argument that the reason for his restraint is due to the Hughes courts dealing with the New Deal and the Constitutional Revolution. He's very critical of that court and how they dealt with the New Deal. Would you agree that that is the reason that leads to his restraint, or do you think, regardless of that happening, he might have been a restrained judge?
No, I don't. I think, first of all, he's not fully restrained, to use your term. That is, he doesn't always support government when it's restricting either economic activity or individual rights. He does partially. But secondly, you're right about his view on the, he expressed that in a book called The Struggle for Judicial Supremacy. Basically said the mistake of the older court was to try to substitute its own ideas of the Constitution for governmental policy. And so he thinks to some extent that the Warren Court is at risk of repeating that in civil liberties areas. But he's not consistent there. He's not. He's an unpredictable jurist, essentially, individualistic, idiosyncratic.
Was he a proponent of trying to gather other justices to go along with his opinions?
Absolutely not. He resented people trying to lobby him, and he made no effort to lobby other people. For him, working out his views by himself was one of his absolute principles as a judge. And that's why some people have asked me, suppose he had been Chief Justice, how successful would he have been? I'm not sure it was a good fit for him. The Chief Justice has to be a conciliator to some extent. If you look at Rehnquist's career, he was very much out in right field as an associate justice, but not as a chief. It's not that his views changed. He just felt more responsible for moderating his colleagues and harmonizing internally. And that's something that an effective chief has to do. And hard to imagine Jackson doing that. I just wasn't his thing, I think. Yeah.
I just had one interesting comment because I love coincidence, but today would be the 80th anniversary to the day of the 84th day of the trial, which is when Jackson and Goring would face off for the first time.
Yes, that's right.
I don't know if we planned it that way, but it's... My question was, though, what was the nation's attitude towards, prosecuting a former cabinet member, a secretary? Was that seen as some sort of retribution from the previous administration?
What are you referring to?
I'm sorry.
Andrew Mellon.
Oh, yeah. The Roosevelt administration quite self-consciously wanted to make Mellon an example of the excesses that the rich were able to get through evading the tax system. They did that on purpose. They tried to indict him for fraud. Jackson said, "You're never going to indict Mellon for fraud. Mellon's from Pittsburgh, and the grand jury's from Pittsburgh, and the case is weak." And Homer Cummings, who's his boss at the time, says, "You go ahead and do it." So Jackson produces a brief, and they don't indict him. So they end up having to try him for non-payment of taxes, and they succeed to some extent. But yeah, it was absolutely a political prosecution, yes.
All right, time for one more.
Yes.
Go ahead.
If I get this right, Jackson once said about the court that we are not final because we're infallible, but we are infallible because we're final.
Yes.
What did he mean by that? I can't understand that.
Well, what he meant, well, why? I mean, why just because you happen to be on the Supreme Court are you gifted with wisdom that goes beyond mere mortals? So that was his point.
Would you please join me in a round of applause?
Thank you.